check your aim. Yeah. Conversation and sample flipping. That's the movement. Hit the like, subscribe, check it. Yeah, for the next minutes of live TV, you stop with me. Got no limits, I'm that vivid, I'm just kidding.
Aspect.
Yeah, what's up,
The
kings and
DPP
queens? We're back
eventually
again
wrote
with an
back,
episode.
and when it wrote back,
This
it
time,
said that
we're going to talk about
we
what
will
was
make a
going on in the case.
decision
Just some
on
of
what
the
to
things
do
that are
with
going
docket
on in the
number
case
2 after the
that are kind of
conclusion of
disturbing,
docket
right?
number 1, which in
It's
our space, in the
controversy
criminal
from left
space,
to
criminal
right.
law space, I beg your pardon,
Ratha,
it was
Judge
shocking
Ratha,
because
unfortunately,
it's not the first
went
time
back on his
that
own
a
ruling.
matter is.
He ruled on a certain aspect of the case, and then he said, "No, I'm going to overturn my own ruling," just because Munisi objected to what Baloyin was doing. And then Ram simply reminded him that you did say that you make a ruling like this. And then he went back on his own ruling. Okay, now let's check about the call that was said to have gone on between Mtokozisi, Mapisa, and accused number 3, right? That call was talked about, right? In that statement of the second statement of Mutans. But guess what? The state expert on calls, the cell phone expert, he never mentioned that call in this case. He never talked about that call. So is he selective when he's investigating this call? Or did he miss that? How did he miss that call? Because he's supposed to be the expert, right? Let me just read on from my script. Okay, again, another aspect. Ntanzi is supposed to be the biggest gun dealer, right? The guy who's moving guns around. But he didn't have a gun that day. He was given just a small gun. The biggest dealer is given a small gun, right? Now, let's talk about another aspect about this gun dealer thing. In fact, let's leave that one out. Let's talk about the fact that Ntanzi, right, he's been a minor all along, right? And the guys come to him and say, no, you've got this job. They know he has never been through that, right? They call him, they recruit him, tell him, now, we've got this job, we got to do someone, we got to exterminate someone, right? And then he agrees. The first time they tell him he agrees, he doesn't even deny or get surprised or ask them, how did you choose to come to me? I've never done this before. How did you come to that decision? No, this guy just decides, no, I'm gonna go and do it. And then after that, they enter the scene. This guy does his thing. Instead of doing his thing, he runs out, right? He chickens. That's what they call chicken as we're playing the street. There's even a game called chicken, right? See who gets scared first. He chickens the fuck out. Sorry for that cuss word, but I'm gonna leave it in the edit. He chickens. Let me emphasize why I put it in. He chickens out, and then after chickening out, they still pay him 45 grand. What type of deal did they make? Or what kind of recognize were they recognizing him for? What kind of work were they recognizing him for? Right, let's leave it out. Now, the contradictions are still rearing their head. The contradiction is still rearing its head. This ugly disease called contradiction still rearing its head in this case, right? In the Cronje statement that was said to have been done by Ntanzi, right? There are now 2 people standing outside the yard being guards. Accused number 2 and accused number 1 and accused number 4, right? which Mamukete or any other state witness or any witness in the house never mentioned that. So you ask yourself, how did Mamukete not see people who were staying around outside, right? And then there was 130% on YouTube. Atlantis calls them 30%. You know those people. And I even agree with him because I did a poll. But anyway, let's leave that. Let's leave the poll that I did. The 30% are saying Ntanzi confirmed the statement of Mamukete when she said she saw 3 people running out. The first one running out and then 2 people running out after. Right. But now, it's now 4 people. So how did Mamukete miss that? How do you explain that, Mr. 30%? I won't even mention their name. Right, let's go on to the next fact. The second story that is new, right, is that people were told to lie down in the house. Nobody in the house ever said they lie down. I don't know why now this is coming through, and then if you are an investigator or even you have that magistrate who was taking their statement, if you could read the whole statement, didn't she want to know, to have some clarity on why are you saying these things? Why does this thing not make sense? And then if you are saying these things, do you know that these things only implicates you? You don't implicate other people. There was no back and forth like that. It was just a story of Ntanzi, which is alleged by the magistrate and the cops who were there. Now, if this guy is allowed to implicate other people and the judge runs with that, it shows a lot. Because after this clip, after like my blah blah blah, I'm gonna leave you with a short clip of a lady called Tabiseng Dubazana. I think it's Dubazana Attorney, yes. She was on SABC today. And then what she talked about was very profound. Very profound. I've never, in fact, I have had a legal mind like that, who's straightforward with the points, who doesn't dilly-dally and try to hide the facts. Elton Hart, the guy from UJ, right? He's always on point with his analysis. And then there's this other guy, I don't remember his, but even himself is nice with his words. But now, this lady, wow, I've just discovered her. I don't know if I can say discovered her, but she's on point. Just listen to what she's saying, what should have happened to this case before. Before they even, after just that de novo, after the trial was made null and void, and then that one of Mongmen, she said this trial should have been enjoined. And there's even a conversation with Maumela and advocate, in fact, Mr. Titi Toban, right, that attorney who was the instructing attorney of Mr. Tefo, right, advocate Tefo. That lady, she's saying, okay, that conversation between Maumela and Titi Toban was saying, they were talking about 375, and Maumela was saying, right, we were supposed to go and meet at the DPC or DP, whatever, at the office there where they're supposed to make decisions on these trials. They were supposed to meet there. Now, what happened was, on the day when they were supposed to meet there, it was supposed to be some virtual meeting. I think Advocate for, I don't know, decided no, he won't go there to that meeting until they discuss certain issues about the accused, like the trial, the fact of the trial. Now, he said no, he didn't see it as particularly direct to the case that they were dealing with. So he called it a block and what, I don't know. I'll also leave a small clip of that so that you can understand what he was saying. They were supposed to block this trial and do whatever with it, so that something like enjoining it to but with Ratha, this was never mentioned. Now I'm starting to feel like the defense let us down in this case, because I think firstly they should have tried to, since they are aware now of the 375, they should have tried to call Ratha to order and say, no guy, there's this other trial here and it's pertaining to the same incident. So why don't we co-join or enjoin or whatever that ladies do with intervention do and say we must join the trials, so that they are now they are being spoken from one court, they are now being heard in one court. No, nothing like that is happening here. So before I make, because there's going to be clips at the end, before I make the video longer, let me just end this video right here on those things. But I'll just add two maybe of my few notes, because I know that clip is going to make it long at the end. But just listen to what that lady is saying. She's on point. Let me add my 2 cents again. Yeah, this other important thing which Gomezulu raised, I think is the only, this guy is fighting Gomezulu. He said to that lady, Kronje, that magistrate, is there a signature there at the end? She said no. What is there? What is there is the initials, right? Then he asked, isn't there supposed to be a signature there? Because at the bottom it's saying signature for both the interpreter, the magistrate, or the officer. Yeah, the magistrate, because it's the, can you say office of the yeah, just the magistrate, and then the deponent, the accused. But guess what? What is there? It's only the initials. And then this comes full circle. Now you get the picture now. When Gomezulu was saying, add some cross-examination, in an earlier cross-examination, when he was saying, the last page did have some blood droplets on it from the accused after he was abused and whatever. Now, guess what? This answers that question. That signature is not there because that page might have just been taken out. And then they put a new page and then they put their own initial. Because with an initial, you can't really tell if that's the handwriting is the same. And I don't even think Ratha is going to even look at that. That the last page of this signature, of this confession, doesn't have the deponent signature. Let's see what he does with that, because we can already tell where this case is heading. We can tell. It's like, again, one thing that I'm thinking this case was they're trying to do with it is they're trying to protect the owner of the gun. I think they know who the real trigger puller is, but what they're just trying to do is protect the owner of the gun. It might be someone strong, so they think that no, can't let this come out, or that guy might have been implicated in some other things, so hence that gun will never appear, that 38 that was being mentioned there. Now listen to that lady and hear what they say. You can see this case is giving the vibes of being dismantled and being sabotaged. With those few words, peace. Catch you on the next video.
And Tabiseng, Tubasan and Tabiseng, thank you so much for your time this evening. I'm sure you're anticipating quite a lot of questions, but the first one, a lot of the viewers have been saying, given the fact that these confessions now form part of the record and Kelly Kumalu's name has been mentioned several times as well, they're asking, why is she not in the dock? Is there anything barring her from being in the dock currently?
If we look back to the matter before it was heard de novo, which is what we are dealing with currently, if you recall, Advocate Mshololo in the first trial had actually inquired on this when the second docket was actually handed in the middle of trial. And she was asking, why is it that we're only getting more evidence when the trial has already started, and evidence that we deem to be quite important to the matter? And then a letter was written to the DPP to get clarity on this. It's investigated by two different jurisdictions pertaining to one matter. Once the one party or the one jurisdiction gets wind of the fact that there is a matter that is being investigated, what they do is that they have a reconciliation. In other words, they get the matters to be made into one. So they don't lose their individual, what we call CAS number, which is attached to the actual docket, but the one that's already in the court roll will then basically absorb the other one, and then they share the new case number within the court roll. That's how it ought to have been done, especially when the matter started de novo, but that's not what happened.
So it sounds like you're hinting that maybe the process wasn't handled correctly from the beginning.
Fully so. It was not handled correctly from the beginning. And the other thing that doesn't make any sense in terms of jurisdiction and all of the likes, the one that we are currently hearing was being investigated within the Pretoria jurisdiction, right? And then the other one was being investigated within the Vosloorus jurisdiction. So even if we're to say one was in Johannesburg, one was in Pretoria, remember that the Johannesburg High Court and the Pretoria High Court share concurrent jurisdiction. So it wouldn't have been a transmission in any matter if one matter was transferred from Pretoria to Johannesburg and one from Johannesburg to Pretoria. Because at the end of the day, even when bail application is conducted in the Vosloorus Magistrate Court, for argument's sake, if the matter was enrolled in the first place, if it was enrolled in the Vosloorus Magistrate Court, a bail application would have been conducted there, but the matter was not going to be heard in the Magistrate Court. It was going to be transferred to the High Court in any event. So it would have been a situation to say that once bail application for the accused persons in docket number 2 has concluded, then perhaps the two matters can be reconciled and then the matter can proceed accordingly. And that was a bit of a problem. I don't know why, but it never happened. And if you recall, in the first trial, before the one that we are dealing with right now, there was also a junior advocate who had written a letter to the DPP on the docket number 2, i.e. the Vosloorus matter, wherein that junior advocate had said, based on the evidence that was collected in that particular docket, there is a prima facie case to proceed against the 7 accused persons in the Vosloorus docket. So as to why that was not followed, we don't know.
So what happens now then, by law? Are they supposed to call the people in the house to be putting them in the dock, or can the person whose name has been mentioned, be seen, be called either by the defense? What happens? What is the rightful process around Kelly Khumalo and the evidence, in fact, the allegations that have been made thus far?
I wish I could give you a straight answer. It is murky and new territory in criminal space, so we don't have a clear answer. Had the process been followed from the beginning, we would not be having this conversation right now. But unfortunately, the process was not followed. So as a result, now the question is, what will happen? The accused person in the docket that is not before this court has been mentioned. What is the state going to do? Is the state going to stand by its averments or its statement in the DPP's letter that was sent in the first trial to say they will await the outcome of this matter and then make a decision on whether or not to charge the accused persons in docket number 2, or will the accused persons unfortunately can't be added at this particular stage. The matter is already part heard. Then there would have to be a situation where the accused from docket number 2, let's say for argument's sake, the state has to add them. We would be looking at a trial de novo yet again, because the evidence that the accused persons in docket number 2 have missed up until this date would have to be put to them as well. So they can't be added in this particular matter. So we just have to wait and see how it is that the state chooses to deal with this matter going forward.
So as murky and as new territory it is then for the criminal justice system, it could be precedent setting, I suppose?
It is 100% precedent setting because it's a high court matter. So us as criminal defense attorneys are sitting there smiling, going, oh, so I can use this going forward until there's an appeal that is going to change whatever the outcome of this is going to be. And from where I stand, I foresee this to be a guilty sentence, judgment, I beg your pardon, based on the way in which the presiding officer is choosing to conduct this matter. I, for one, do not agree with a number of things that he does. I don't agree in the manner in which he deals with evidence. I don't agree in the manner in which, when objections are raised on procedure, he accepts that procedure can be bent to a certain extent and not follow the letter of the law. But when it is brought up in a manner that puts him in a dark corner, for lack of a better term, only then does he recall that procedure ought to be done this way. So from a defense attorney point of view, it seems like the presiding officer is behaving as a prosecutor instead of being objective in this matter. A number of evidence-breaking admissions that he has done so far, inclusive, in my humble opinion, of course, of this confession that has been admitted. Too many flaws were noted in the trial within a trial, but we all expected him to accept it based on the way that he's run the trial so far.
You are telling me about the implications of 375, the docket, on this case. I haven't, and I wouldn't have read 375. Advocate Mshololo is saying up front, it was only discovered this morning, and she is still to read it. I don't want to get into what Advocate Baloyi was saying, but if it was discovered this morning, surely they need time to read. I also would be disagreeable to a lengthy postponement, but there would be reasonable time needed, a reasonable time period needed. And this sends me back. You remember we attempted to meet the DJP in order to enroll this matter and block. The DJP being agreeable, suggested that we meet. It turned out that we cannot all meet during daytime, and we agreed upon a meeting virtually after hours. We agreed on the time and the day. On the morning of the day we were supposed to meet to do that, to avoid these lengthy postponements, to avoid this trial lasting forever, we received communication. I received communication through the secretary from Advocate Defo, saying he cannot engage in a meeting. I'm sorry, I'm having to quote him in his absence, but you are the instructing attorney. He cannot engage in any such meeting before we discuss certain events that happened in this case, which in my humble view didn't have anything directly to do with this case. I'm saying this to say to you, finding time and ensuring that this case is speedily finalized has been my objective from the word go. And in due time, we had convinced your colleagues to be of that idea. And when we were just there, where you will remember that each time we postpone a matter, there are other matters that come into the fray. And we were fortunate in that the DJP was willing to deliberately make that happen, but we could not. But maybe this is awakening us to go back to the original plan, to see the DJP and agree on enrolling this matter en bloc. But I don't think I can be convinced to go along lines that will deny Advocate Mshololo reasonable time. I haven't heard her about the postponement.
I do agree with my lord. Yes, I submitted earlier before adjourned that we don't have a problem with adjournment, postponement, but we suggested a shorter period. We agreed. Then there was change of minds that no, it must be a lengthy one.